Court of Appeals, First Appellate District of Ohio, with the Honorable Marilyn Sias presiding, is now in session. Please be seated.
Good morning. I hope everyone's having a great week. So we're here on a Wednesday. Normally we're here on Mondays and Tuesdays. It's good to see everyone. So this is Wednesday, June 8th, and we have two cases set for oral argument this morning. If attorneys can please identify themselves and their readiness to proceed. The first case that we have is State of Ohio versus Antonio Reed, which is case number C200104.
For the appellant, Your Honor, David Hoffman, is ready to proceed.
For the appellant, Chris Tabisky, ready to proceed.
Mary Stewart with the state, ready to proceed.
Okay, thank you. And the second case we have is State of Ohio versus James Edwards, case number C200101.
Chris Tabisky for the appellant, ready to proceed.
Paula Adams on behalf of the state of Ohio, ready to proceed.
Okay, thank you. So on Antonio Reed, are you dividing time?
Well, Your Honor, I was prepared to address the probable cause and the motion to suppress.
Okay.
And if the court had any questions on the sentencing, Ms. Gieseke would step in there. So I didn't intend to divide. I didn't intend to raise the to actually address the sentencing, but if the court wanted to ask questions about it, I guess I don't know how you work this out.
Okay, so let's, all right. Because it isn't so much about us, it's more about, preparing for you to know what to expect as well.
I can simplify it. We'll divide our time. That's all right with the court. I'll take 8 minutes, and Ms. Gieseke could have whatever was remaining if the court would have any questions.
All righty. So, we can add time, and obviously both sides will have an equal amount of time. I'm assuming that you're fine with that.
That's fine.
Okay. And so, we can either do 20 or 30 minutes.
I'm not going to take that long.
Okay.
I just wanted to address the probable cause, and if Ms. Gieseke would have anything to add, if the court would have any questions.
Yeah. So, Attorney Gieseke, if you want to weigh in on that.
Ms. Steer wants the opportunity, since I'll be arguing Reagan-Stokes constitutionality in the next case, but that case will be Ms. Adams. So it really depends on if Ms. Steer wants to weigh in on Reagan-Stokes in this case or not.
Well, obviously, I want to address the assignment of error that's been presented to the court.
Okay.
So I will be most likely touching on it. I don't expect to be taking very long because I think I've covered it pretty well in my brief. So.
Okay. So if we said 20 minutes, do both sides feel comfortable with 20 minutes?
That's fine. That's more than enough for me, I'm sure.
Okay. All righty. All right. And so, Attorney Hoffman, so within the 20 minutes, you would like how many of those 20 minutes?
10
Okay.
minutes, Your Honor.
And how many would you like to reserve?
3 minutes for rebuttal.
Okay, so you'll have 7 now, 3 later?
Correct.
All right. I can still do my simple math.
It's getting more and more complicated.
The older you get. And as much math as I took in college, because I was an engineering major. And I have to whip out that calculator now sometimes. All righty.
May it please the court, Mr. Dyer. I represent Antonio Reed in this case. This is an appeal from the denial of a motion to suppress. Generally speaking, police do not have probable cause to arrest for possession or trafficking in the case where they believe they see what looks like a drug deal, but they cannot see what's being exchanged. They don't see the drugs and they don't see the money. And here the trial court upheld a full search for evidence on the basis that it found that there was probable cause to arrest. And it made that finding based upon a similar scenario. Police saw what they thought was a drug deal, but they didn't see the exchange of drugs or money.
Wasn't there more to it, though?
There's a lot more, yeah.
It wasn't just that they saw two people that they thought might have exchanged drugs. They were investigating a guy apparently for a while, right, and had some drug intercepts or package intercepts, got money from him. There was a long investigation.
Mm-hmm.
And then your client gets into, and then they watched what they thought were drug deals at this UDF, and then your client gets into his car, they see a very similar thing that they thought was a drug deal, So there's more to it than just, right? That they just saw
There's a
what they
lot
thought
more.
was a drug deal.
Yeah.
Right.
And so these cases are difficult because they're very fact-specific, but
Right.
if it still boils down to the reputation of the drug dealer. I mean, you'll find cases where you have exchanges that look like drug deals, but like the Eppinger case, you don't see what's being exchanged. And the whole determination of probable cause is based upon the reputation of the drug dealer and the defendant's association with that drug dealer. And it's the same thing here. It's just that it's on steroids. You have a super drug dealer, and you have a person that the police didn't know about up to this point, and you don't see what's being exchanged. It's the same thing.
Well, I mean, in essence, it comes down to what did the police officer know at the time of the stop? Because anything that is determined afterwards is determined afterwards.
That is correct.
So what is it that the police knew at the time of the stop?
Okay. At the time of the stop, they only knew what happened at the UDF. There was no new evidence that was generated at the stop. And the stop, and another thing is, all the information about the drug dealer, Damian Dennis, his history, without seeing what was exchanged, I agree, it's very suspicious. It's a reasonable suspicion. But my position is it isn't probable
Go back and
cause.
respond to my question.
Okay, sorry, I got off the track. They had a known drug dealer pull into a UDF and not purchase anything and wait there in his car, and another person pulls up in his car. He gets out of his car. The other person doesn't buy anything either. He gets in the drug dealer's car. There's some sort of an exchange. The person gets back out of the car, nothing in his hands, gets back in his car, and both drive off. And this happened several times in the same day, on May 7, 2019, at this UDF. It's
Several times
Vine Street in
with your
Goldberg.
client?
No, my client only came there once
Oh, with Dennis.
with Dennis. But Dennis comes there several times in the same day, and they see the same thing. But they never intervene in these other cases.
Wait, I thought that they actually seized packages and money from him, from Mr. Dennis.
Oh, yeah, he has a reputation as a drug dealer. That's why I said known drug dealer. He's a known
Okay.
drug dealer. I thought I would cover everything. I mean, he's a really big shot drug. He gets his
Did you
drugs
call him
from
a super drug
Mexico
dealer?
and yeah, super drug dealer. Yeah, but still, it's an association with a person with a reputation. And my client was unknown to the police when he pulled in there, and they didn't see what was exchanged. There's no probable cause. There's a reasonable suspicion, and that's why this search for evidence was bad. It was a search incident to arrest, but there was no probable cause to arrest, because when they got there and the officer Wigan ordered the police to stop my client after he saw what happened at the UDF. And it was at 8376 Anthony Wayne Avenue where the stop took place. It's close to the UDF, but it was at my client's destination. This wasn't a traffic stop where they caught up with him. As a matter of fact, when you look at the body camera footage, this wasn't a traffic stop. It was like a stakeout. The police were there first before he got there. And how that happened is not explained in the record. But at any rate,
So you can see that they could have done a Terry pat down, but your argument is that this went beyond.
yeah, and those police agreed with me at the scene. They started with Terry pat-downs, but they couldn't find the drugs. Twice they did it. And then as a last resort, they went ahead and did this, and suddenly the body camera is diverted at the time of this search for evidence. But anyway, the trial court still upheld it because he held that UDF activity was probable cause that would support this search. But they didn't see what was exchanged. They didn't see the money or the drugs.
So
And
that's what we would need in a case like this, you're saying. Even what you have trained police who've been watching in your words, I guess, a super drug dealer for a long time, do what they believe is a drug exchange with your client. And you're saying that cannot rise to the level of probable cause unless they actually see drugs or money?
Well, you can't. I started out by saying generally that's the case. Yeah. If you don't see what's being exchanged, you've got a reasonable suspicion, not probable cause. And if you look at the case law, a lot of these scenarios start out with a stop. The police treat it like a reasonable suspicion, and then they continue their investigation, and the drugs come up during the pat-down.
So in this case, though, the stop with your client, or I'm sorry, the interaction between your client and Mr. Dennis, that was the exact same pattern that they had observed this known drug dealer do multiple times over the course of the year. And they knew in those other occasions that he was indeed dealing drugs, correct?
Actually, I don't think they testified to that. I remember the events, he said several times that day, and he said each time it was exactly the same. In other words, they couldn't see what was exchanged. And they never found out what was exchanged from those other events. They never stopped anybody at those. There was no testimony that they did.
That's what I was going to ask you. I mean,
Yeah.
so how long were they surveilling Mr. Dennis? Do you know?
It was hard to say. All I know is that that big shipment that was caught was before this happened. But they said up to a year they had been following him, but I don't know where this fell in that year.
But where they were watching him at the UDF, you're saying that there was no evidence that they had ever pulled anyone else over that they believed had done a hand-to-hand exchange?
No. As a matter of fact, they even wondered why they pulled over my client, who they didn't know about, and not Damian Dennis, and they just said it was a lack of manpower. And
Of why they never pulled anyone over before?
No, why they chose my client over.
Oh, over
the super
Dennis?
drug dealer, yeah.
Okay.
So, if you don't mind, I'd like to get a little drink of water in my mouth.
That's fine. And just so you know, you have about a minute of your 7 minutes.
Thank you. This case involved a determination of probable cause based upon the drug dealer's reputation. There was a reasonable suspicion, but the search that was conducted for evidence exceeded the scope of a Terry pat-down search. It was unconstitutional because there was no probable cause. The court erred in overruling the motion to suppress, and the judgment should be reversed. There are no further questions. Thank you.
Thank you.
Good morning.
Good morning.
May it please the court, Ms. Steer?
So Attorney Gieseke, so you have 10 minutes,
Okay,
and how much of that would you like to reserve?
I'll reserve 2 minutes.
All right, so that gives you 8.
Okay. So I'm sure this court is very familiar with the Reagan-Stokes law. I'll just do the briefest primer. As you know, the law went into effect in 2019, and it hearkened to the return of indefinite sentencing. There is the minimum term from the established statutory range for qualifying F1s and F2s, and then a maximum term. The inmate, after he serves the minimum term, is rebuttably presumed that he'll be released. But ODRC can hold a hearing and rebut that upon certain enumerated statutory findings. So we submit that the Reagan-Stokes law violates the Constitution on numerous fronts. I believe the strongest are procedural due process and separation of powers. Skip ahead a little bit. So on separation of powers, really the crux of the argument is that even though the sentencing court imposes the indefinite range in name, it's actually ODRC that wields the power. So if you recall, Revised Code 296711 back in the 90s was colloquially called the bad time law, and that allowed DRC to extend an inmate's term beyond the initially imposed term. Now, the bad time law was stricken as violative of separation of powers under Bray. And the Bray court found that that law impermissibly shoehorned the executive branch into the roles of prosecutor, judge, and jury. And we submit that the Reagan-Stokes law, although in name purports to give the trial court the power, really in practice does the same thing that the bad time law does, or did.
I'm struggling with the separation of powers issue.
Sure.
Because, I mean, it is the trial court that gives the entire sentence,
Right.
and including the tail end. So it's the trial court that hands down the entire, let's say it's 8 to 10 years.
Right.
the presumption is 8, but the trial court still says that the defendant can get up to 10 years. So if it's the trial court that is handing down this potentially 10-year sentence, where is the violation?
Right, and that is the way that I think the legislature tried to insulate this from the same fate as the bad time law, is in the verbiage. So they said that the trial court, and I think the 8th District in Delaval too seized upon this distinction and said that the trial court imposes the sentence, whereas ODRC maintains it. And on the surface, that does seem to save the law, but we would still say that, again, it's DRC and their entirely internal procedures that really decide whether this inmate's stay is extended.
So does it make a difference in this case that there is that presumption? I mean,
For the separation of powers argument, I would say no. Possibly for the due process argument, yes. But I think it's important to note that the reduction for good time under the same scheme, that is actually, it goes back to the trial court. The sentencing court has a say in that. There's a whole procedure.
That's to go under the minimum, right?
Yes,
Okay.
so that would actually change the sentence.
it would. But we would submit that to insulate this, and it really does go more to the due process, but to insulate this, that if anything, that the maintaining it or keeping someone longer should go back to the trial court to really have the trial court be the one to have the power, so to speak.
Now, just going back, I know Judge Bach asked you this, but I just want to clarify. If there were no presumption, we would just be back to the indeterminate sentencing that has been held to be perfectly constitutional, right? If there was no presumption, I mean, that seems to be the key here, right, for your separation of powers argument?
I suppose it does change the analysis, but the argument for I presume you're talking about the indefinite sentencing that's life tales that goes along with murder, ag murder.
Because, I mean, maybe you could set me straight on this, but the way I was kind of looking at this and the reason why I thought courts were saying that this indefinite or indeterminate sentencing is okay, and it's okay for the adult parole authority to determine if somebody gets out, is because the presumption is that the person's going to be spending the entire time, and that the adult parole authority then basically mitigates the sentence and allows them to get out early.
That is true.
Which is different here. This is the exact opposite, right? So I guess that's what I'm asking, is that if the presumption is what the big problem is with Reagan-Tokes, because if it weren't there, we would just have the indefinite sentencing, right?
Right. And I suppose that is, if anything in Reagan-Tokes, that would be the lifesaver for this whole scheme. But it still doesn't change that it is ODRC that maintains the term, which is the same as, they're still depriving the person of their liberty. It still is them making all decisions and wielding the actual power. So it comes down to, if you don't agree with that argument, then the separation of powers would not be the strongest, if you think that the presumption is the saving grace.
So with the separation of powers, is there a distinction between rule violations and unprosecuted crimes?
There is, and I think, even though that hasn't been fleshed out, I think the reason that must be is double jeopardy. Something is prosecuted internally, and then they use that to also maintain the prison term. I suspect that would be a double jeopardy violation. So my guess is that's why there also is a process before the Rule Infractions Board that Reagan-Tokes borrows from. So that's another distinction, and I don't know that goes to the separation of powers argument, but that's another distinction between those various levels why someone can be held.
Okay.
Yeah. And I don't think any court has actually fleshed out that either yet, why that's a difference, but my guess was double jeopardy. So I will skip ahead to procedural due process, because I do think that is the strongest argument. As you know, procedural due process requires notice and an opportunity to be heard. And under Matthews v. Eldridge, the seminal U.S. Supreme Court case, that has to be a meaningful and appropriate opportunity to be heard. So we would submit that the Reagan-Tokes does not afford that level of due process, procedural due process. First, the notice afforded by the Reagan-Tokes provisions we would submit is not adequate notice. So as you know, the inmate can be held for longer for a number of reasons. One is the rule infractions. Another is that they were in restrictive housing within the year prior to their hearing date. And then the third is any violation of law that's not prosecuted separately.
You have about a minute of your 8 minutes.
Okay. So we would submit that notice, it's very broad and vague. There are 61 rules alone in the administrative code, and then you add to that any violation of law, and the possibilities are huge. So the second part of the notice prong, though, is easier to quantify, and that is that the Reagan-Tokes provisions themselves don't provide for notice to the inmate. So they reference, I believe it is the parole statute that says notice should be provided to these parties, and it is the sentencing court, the prosecutor, and the victim. And so the inmate is not named at all in those notice provisions. I know it's almost done. We'll get to this more in the next case, of course, but the opportunity to be heard is severely lacking when you compare Reagan-Tokes to parole eligibility hearings, parole revocation hearings. And I did file a supplemental authority last week, those policies by ODRC, so you can look at them side by side and compare the process. And I think that really is the important part of the due process analysis, because even the Delaval court didn't do that. They discussed ODRC policy 15, which is the Reagan-Tokes hearing, but they did not compare it. Even though they say that Reagan-Tokes additional term is kind of like parole revocation, they didn't then compare the procedures. So I think that is one thing none of the courts have done so far that is really imperative. Because if you're going to shore up the procedural holes in the Reagan-Tokes statute, you need that policy. If there are no further questions, we also submit, and I do believe Delaval did not go over equal protection at all. So that is another, whether it's quickly rational basis or strict scrutiny, there's the whole constitutional paradigm, and we would say that it violates both. And that argument is preserved in this case as well, and in our other cases out of my office. So this court will have a chance to address equal protection, whereas the other courts have not yet. If there are no further questions, I'll go ahead and close. Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
Counsel, may it please the court. So I'll start with the stop and then move over to Reagan-Tokes if I have time. Hopefully I won't be using up 20 minutes. With respect to the stop, I want to clear up a couple of things that were in the record as far as the investigation that was going on. Police officers, the task force was investigating Damian Dennis for over a year. That's what Officer Wigan testified to. They were not sitting there at the UDF this day watching multiple hand-to-hand transactions. What Officer Wigan said was that they knew that Mr. Dennis had been going to this UDF. They had watched his process. He would pull up to a gas pump. He wouldn't get gas. Another car would pull up. Someone would get into his car, and then they would leave. No one would get gas, which it's not just pulling up to a parking spot at a UDF. They're sitting at a gas pump. On this occasion, Officer Wigan said that they had been following Dennis's car. I'm assuming, I don't know if they had GPS or what on him, but they figured out that he was headed to the UDF, as was his usual practice. So they went there, and then they witnessed the transaction between him and Reed. Reed, same thing. At the gas pump, Reed pulls up, gets into his car. Officer Wigan said he saw them exchange something, but he couldn't see what it was. Contrary to, I think, what Mr. Hoffman said, he didn't say there was nothing in his hands. He just couldn't see what there was. I don't know that he testified about seeing his hands once he got out of the car. Once Mr. Reed left the UDF, then Officer Wigan, who was undercover, called uniformed police to make a stop. He told them to stop him, I think, because of window tint, just to give them a reason to stop him. I think that then they testified, Officer Knapp also testified that a lot of times they'll stop someone, they pat him, Officer Knapp patted him down either once or twice. It was kind of unclear. I think he patted him down twice. Officer Knapp also told him he was just checking warrants because he said he wanted to keep him kind of calm because the guy had been kind of acting a little nervous. And then once Officer Wigan was there, he took over and did the actual search. So
Had
that's,
they planned to arrest him already?
they had.
They testified to that?
Yeah, Officer Wigan said that he called the police officer, he radioed it in because he had probable cause because of the drugs transaction that he saw at UDF. He also testified that he figured that Reed would have the drugs because they knew that Dennis was the drug dealer. So they didn't assume, they figured the drugs went with Mr. Reed. So he knew that when he stopped him, either the drugs were going to be in his car or on his person.
But they didn't find any drugs in the initial pat down, so.
They did not,
So why would they continue to want to arrest him at that point?
Well, they already had probable cause because he had seen the transaction with a known drug dealer. So he had probable cause before. I think that that's what Mr. Hoffman was arguing, is that they didn't have probable cause until they found the drugs. But actually the probable cause started at the UDF.
Well, he's arguing they had a reasonable suspicion to stop and investigate.
Correct. But
to just do a pat down.
Right, but the state would argue that they actually had probable cause. And if I could, I'm sorry, I should have stepped back. None of this probable cause was raised at the motion to suppress hearing. The question at the motion to suppress hearing was, and this is what the judge said, the defense's position is that Mr. Reed was not under arrest and was beyond a Terry stop. The whole question was whether or not he was under arrest and whether or not it was the Terry stop gone too far as the extent of the search.
Isn't by implication, doesn't that mean that they're saying there was no probable cause, though?
I don't think they were, because they weren't saying that he was under arrest at all. So they were trying to say he wasn't under arrest, and they said he was handcuffed, but that it was all completely a Terry stop. So the issue of whether there was probable cause actually to arrest him, I don't think they even touched on that because they didn't think he was under arrest.
But but probable cause was argued by the state, right? I mean, the judge found probable cause.
They kind of skipped over that, though, what I'm saying is they kind of skipped over it to the fact that he was arrested and then it was a search. Then it was a search following an arrest.
But necessarily you have to have probable cause to arrest.
Yes.
And the judge found probable cause.
Yes.
So it seems like that was the issue at the hearing, or one of the issues.
Yeah, I just don't think it was addressed as clearly like when the probable cause was developed.
Okay. So you're saying they waived this argument?
Yes, but I think that it was, I think regardless, it's clear that probable cause existed from the time that Officer Wigan saw the transaction at the UDF with a known drug dealer. This was his practice. This was how he did his drug deals, and they knew that that's what they had with him.
Can you please address Mr. Hoffman's assertion that generally an officer would have to see what was exchanged, see that there was drugs or money or something more than just seeing what they saw there?
I'm not sure. I'm not sure of any case law that says that. I think I could see a situation when it was a one-off transaction. So say just a police officer happened to be on the road or even happened to be at the UDF, saw some guy get in the car, saw him get out. I think probably then, if it was a one-off and the police officer couldn't testify about the drug dealer and what he knew about him, I could see then that maybe that would only be reasonable suspicion. It wouldn't be enough to rise to probable cause. But I think that you can't have a bright line rule that the police officer has to see something in the hand and has to see money exchange hands. Probable cause doesn't mean it has to be within a certainty. It's just a reasonable belief that a crime has occurred. So it doesn't have to be, to a certainty. And that's what I think that's where they kind of were, in the hearing, they said, but you weren't certain until you searched him. Of course, he wasn't certain until he searched him, but he knew what he had seen, and I think that he knew that there had been a transaction. I think he had probable cause. I don't think he had to necessarily see the actual drugs in Reed's hand.
Well, he didn't know there had been a transaction. He suspected there had been a transaction.
I think he knew there was a transaction based on what he saw at UDF, because it was the practice, because again, relying on what he had known as the practice of Mr. Dennis, he saw Antonio Reed get in his car. He saw some exchange happen. He didn't, and then he saw him get back in his car. And I think he knew that there had been a transaction. And I think he knew he was going to find drugs either in the car or on Reed's person. So I think that there was probable cause, and it was more than just, a one-off. He had when you read the transcript, he knew, the practice of Mr. Dennis. They'd been watching him for over a year, and this was the way he did his sales.
Was there more information about I know there were some package intercepts and they seized money. Was there more information at all about the package intercepts?
He, on page 9, Officer Wigan said, "We intercepted packages we believed were intended for him. We seized hundreds of thousands of dollars from him, from his car, from his bank accounts."
Packages of drugs?
It just says packages.
Okay.
I just assumed it was hopefully not.
Well, that's what I was wondering.
Things. And he also said, I think at some point he actually said that he knew he was, it was an international drug dealer. I can't find that immediately in the. So I think that they had more. I would guess that he wasn't going to go too much in because it didn't sound like that investigation was necessarily over with Mr. Dennis. I don't know if Mr. Dennis. No one talked about whether or not he had eventually been arrested or where they are in that investigation. It sounds like it might be something beyond the local people.
So the line here is if the officer had just saw Mr. Reed go up to somebody else that the officer was not familiar with, do what the officer believed was a drug exchange, no probable cause there.
I think you would probably have a reasonable suspicion then. I think you would probably have a hard time showing that his belief, going into whether or not his belief was reasonable as far as there actually having been, because I don't think you have that backup. So I think that it would be more a factual issue that I think would have been more of a problem.
But if the police know that one of the people is a known drug dealer and they see the same exact transaction, then that rises to probable cause.
Yes.
That's your argument. Okay.
And I think it's different from, this isn't even just like a case of someone running into a building and running back out, running into a known drug dealer's building and then running back out, right? This is, they actually saw something. He said he saw some exchange happen. So it's beyond, it's not just a guy sitting in the car also. Mm-hmm. So there's a lot of facts. And I think when you look at the totality of the circumstances, he did have probable cause. Because he had probable cause, he was able to arrest Reed, even though they didn't say you're under arrest. Clearly, he was under arrest. Officer Wigan testified he wasn't free to leave, that he was going to charge him. And then I know that I think it was Officer Knapp who did the pat-downs. I think Officer Knapp said he did the pat-downs because even if they have them cuffed, if he has something, he can maybe still be a threat. So he did pat him down. But I think Officer Wigan actually conducted the actual search of his body, and that's why it was much more invasive, and that's how he found the drugs.
He testified he was going to charge him before he found the drugs?
No, I'm sorry.
Okay.
I misspoke. No, he testified that he was under arrest when he stopped him.
Okay.
Yes.
Rather than sharing with us what you think as to why there was a second pat-down, what does the record reflect as to why there was a second?
Why there was a second pat-down? Officer Knapp's second pat-down, or so there was testimony. I think when I was reading this again yesterday, I think Officer Knapp did 2 pat-downs. I think he patted him down like quickly when he got him out of the car, perhaps, and then he said usually when he pats people down, he moves them, I think, to the rear quarter of the car so that if the guy should run, he can't run. It kind of traps him in. So I think he patted him down again, but I think he said he was still trying to hold on to him so that he couldn't conduct a better, more thorough search. So he was holding on to him, and that's why Officer Wigan came over then and did the body head to toe. I think they call it a head to toe search, and then that's when he also went into his pants and then felt the lump and shook it out of his pants. I believe that's my recollection of the
Okay.
record. It was kind of confusing. I think there was some question at first if there was just one pat down and then the search, or if there were two pat downs, and I think it seems as though Officer Knapp probably patted him down twice.
So he was in handcuffs during the
Yes.
second search?
Yes,
Okay,
he was.
thank you.
I think almost as soon as they got him out. And
Right.
I'm trying to remember from the video. So, unless you have any questions about that, we would ask that the trial court's decision denying the motion to suppress would be affirmed. Now, I'll switch gears to Reagan Tokes.
So you have about 8 minutes.
Okay.
Okay?
First of all, I'd like to point out with respect to Reagan Tokes, all of these arguments have been made in cases, especially apparently the 8th District has a ton of cases. All of those have gone up to the Supreme Court. The Supreme Court has accepted 2 cases for argument, for briefing and argument, Hacker and Simmons. I think Simmons is from the 8th District. I forget which district Hacker is from. Those cases are being briefed. Hacker they got an extension. Their briefing is due June 13th, and then the briefing on Simmons is going to be due June 20th. So
Are we expecting an argument this year?
I am not, and it's funny, so we argued this last week.
Right.
Another case, the same question came up. In my experience, the Supreme Court generally stops hearing arguments in August,
Right.
particularly since one of the justices will be leaving, and so they need to get all of the cases done, so they quit taking cases. So I suspect that the case won't be argued until next year. Because I was kind of doing the math, if they don't have briefs due until June 13th or June 20th, the other side has 30 days to respond, and then I think another 20 days. So
Right.
that already puts them out to August. And I think that they don't schedule those hearings, those arguments right away. And in fact, I forgot to look. I was going to look where the oral argument is now, but I'm pretty sure they have oral argument scheduled out through the summer already. They probably already have all of their cases.
And then the decision will take a while.
Right. And I don't know, I think it's probably up to the chief to decide, how she's going to schedule the arguments and everything like that. But I just suspect, and also I think despite, I know that the Supreme Court found that it was ripe, but there's not like a huge urgency because most of these defendants are already serving fairly long time. So it's not like someone's going to get out. I don't even know that one of these disciplinary hearings I don't think anyone's had their time extended beyond.
Except in cases like this that we need to hear because there's a Fourth Amendment issue.
Correct. Yes. And then otherwise, with respect to the actual merits, I think Ms. Gieske referred to that Del Valle case. 7 districts have looked at this. All 7 districts have found that it's constitutional. The 8th district, I think they had 3 panels that did hold it was unconstitutional. So then they went through an en banc hearing, and that's the Del Valle case. I'm sure you've seen it, but it's 2022 Ohio 470. Judge Gallagher, who wrote that, I think was on the Sentencing Commission. I think he still is. So he's obviously super thorough when he writes, but I think he makes some good points. You can't discount the point that the trial court is setting the minimum, and by virtue of setting the minimum, is setting the maximum term. And
The trial court has discretion, right, on determining the minimum?
Yes.
And then based on that minimum, you calculate the max.
Correct. Then it's like a formula. So it's half of the minimum you add on to it.
Right.
And there's actually currently some legislation going through. They're going to kind of clear that up, I think, a little bit more. But it's going to be the same thing. It's going to be half of the minimum term. Because the trial court sets that, all the parole board's doing is, like Judge Gallagher says, they're maintaining them. They don't get to extend a prisoner's time beyond the sentence that's already set by the trial court. So there's no separation of powers issue. This is not like bad time where they got to add time to what was already set.
But aren't they still trying I mean, basically, in essence, trying somebody and potentially convicting somebody?
Well, I don't think that they are convicting someone.
Well, I mean, if it's an unprosecuted crime rather than a rule infraction, let's just look at that.
Yes.
Because I think that that's a different analysis. So if it's an unprosecuted crime, and that's the reason why they're getting the tail end of that sentence, aren't they trying them to see, to determine their innocence or guilt of a unprosecuted crime?
Well, I think when you read, and I'll refer to that Del Valle case again, just because he's so thorough in what he wrote about. But the separation of powers doesn't mean that everyone has their own sandbox and no one can kind of mix in. It only means that you can't usurp the other branch's power. So there's plenty of times when there are hearings that the parole board does where they're essentially, I mean, it's the same thing with any like parole board infraction where they're hearing and keeping someone, either maintaining someone in prison, or if there's a parole violation and they're violated and they have imposed more time. So it happens all the time. It's not a full-blown, it's not a conviction. They're not usurping the judicial branch's ability to convict someone for a crime. So I think it is different.
Well, the issue isn't the conviction. The issue here is the sentencing.
Correct. But,
So I don't think we're concerned that the power to convict is being usurped here.
correct. Well, I think going to Judge Bach's question as far as whether or not we're letting the parole board essentially find someone is guilty of an infraction,
Okay.
thus extending or not getting them out at the minimum. And I think that as far as the presumption, I think actually that is more helpful. The parole board, my understanding is that the parole board, as far as parole hearings, there is no presumption. Here, they don't have unfettered discretion to maintain someone beyond their minimum because of the presumption that they will get out at their minimum. They have to find actual infractions to be able to keep them beyond the minimum.
Yeah, but
so there's a presumption.
But I guess for me, the way I look at it is when you have your indeterminate sentencing, the presumption is that you're going to do the whole thing unless you get mercy and get out early, right? Here, the presumption is that the minimum term is sufficient for the crime that you committed. And then any additional time that you're going to get is going to be not based on the crime that you committed, but it's going to be based on other things that you did while in the institution.
Right, but I still think because that falls within what's set by the trial court, that there's not a separation of powers issue.
Because there's a maximum.
Because that's already set, and nobody is challenging the ability of a trial court to set indeterminate sentencing. Indeterminate sentencing was around for a long time before. It's only with I think it's Senate Bill 6 in 1993 or 96 when they brought back determinate sentencing. That indeterminate sentencing was around for a long time before that, and it wasn't stopped because it was unconstitutional.
Do you think the implications, I know that Judge Gallagher in his Del Valle opinion said that the implications of finding the Reagan-Tokes unconstitutional will be that the rest of the indeterminate sentencing statutes could potentially also be unconstitutional.
I think that I don't know that they would be. I think because the way that right now it's been framed, I'm assuming that when these cases are decided, if any part is found unconstitutional, they'll be able to excise just that part. I'm not sure that because there hasn't been a challenge to indeterminate sentencing and the role of the parole board itself. I think he was more upset just about the general, it's unconstitutional without kind of specifying exactly where and what you're going to be excising. If I could touch real quickly on due process.
Which I think there's a differing perspective because the dissent seemed to say we are being specific as to
Right.
what is unconstitutional, while the majority is saying that dissent is not.
Yes. With respect to the due process argument, I understand that everyone's looking at that policy 15 to see whether or not it's, there's enough hearing. I think that's not a ripe issue right now.
That's what I was wondering. Why are people, and we'll get into this more, but why are we looking at this policy? Or should we not just be looking at the statutory language?
Agreed. And under the statutory language, as long as they're given a hearing, that satisfies due process.
Is it a meaningful hearing, though? I mean, it's my understanding that the defendant, first of all, is not required to get notice under the statute. Everybody else is, but it doesn't specify that the inmate is required to get notice, first of all. Secondly, it's my understanding that the inmate does not get to provide the defense that he or she wishes to provide. DRC gets to choose whether they're allowed to present certain pieces of evidence.
And that's why I think that's an argument that's coming down the road, because I think that at this point, when you get the sentence, when you get an indeterminate sentence, you're getting all the due process that you're due. You're getting there's going to be a hearing, whether or not there's notice. I believe that there's other parole requirements that the prisoner is giving a hearing, and I'm sorry, I don't know that right offhand. But I think that as far as whether or not, like what happens at the hearing, what evidence can be presented, I think that's a separate challenge for that process. And I don't
But right now we are looking at the statute and the code. So, I mean, looking at that and what that provides, does that provide a meaningful opportunity to be heard?
I think that if you presume constitutionality, you presume that the hearing that is provided for is meaningful. I think you can't go beyond.
The statute doesn't have to say that, because it has to be meaningful per the Constitution.
Right, and I think that I just don't think that we're there yet. I think that's the problem with some of these challenges and without having had, as far as I know, I don't know that anyone's actually had a hearing. I know I had a case just recently dismissed because the woman already got out.
Are you thinking that it's not ripe? Is that what you're basically saying?
As far as challenging the quality of the hearing. I mean, obviously the state argued that it wasn't ripe. The whole thing wasn't ripe, but we got past that part. But I think as far as like the adequacy of the hearing that's provided in those policies and exactly what happens, I just don't think.
So we're past your time, well past it.
I did talk more than 20 minutes.
But you also had a lot of questions. If you want to say something to wrap up.
No, we would just ask that you affirm.
Okay.
Thank you.
My turn. Please, the court. The window tint information was, I recall, from the bill of particulars, and I don't think it was testified to specifically at the hearing on the motion to suppress. But it does appear to be consistent with the position that the police felt they had a suspicion, a reasonable suspicion, and not probable cause.
Was he charged with the window tint, by the way?
Yeah. And also, if you look at the recordings, there's no mention of the basis for the stop. They didn't mention the UDF, and they didn't mention broken, lens on a turn signal or anything, window tint.
And I understand that, but regardless, I mean, we have to look at the totality of circumstances.
Correct.
Of what led up to the stop, what did the officer actually know at the time of the stop, and whether that was enough, because of how everything played out, when it culminated to where it did, whether there was enough of probable cause.
Certainly. At the motion hearing, the written motion to suppress claimed that there was no reasonable and articulable suspicion for the stop, as if there was no information about the UDF event. I suspect maybe the body cam, there's no recording of the UDF, by the way, it just was testimony.
It's just the officer's observations.
Officer Wigan testified to it, yeah, even though he testified to watching it on camera or TV or something. But anyway, and so it seemed to come as a surprise at the hearing. And so the hearing morphed. The Officer Knapp testified that he was questioned about the difference between a pat down for weapons and a full search for evidence. And he made the comment that in a drug investigation, there's no need for a distinction. And then I think that might have prompted the trial court to make the finding when he ruled on this motion that, yes, it was a full search for evidence, but it's backed up by the probable cause the trial court felt that was obtained at the UDF. And my point is that if you say that you don't need to see what's exchanged in a supposed drug deal, I mean, the police could go out and arrest people without any CIs, no controlled buys. I mean,
I don't think the state's arguing that. The state argued that if it was simply a hand-to-hand, what he saw, without any information about either of the two people, then I believe the state conceded that probably would not be PC. What they're saying is that there's the added information here that the police know about one of the people in the exchange, and that's what makes it rise to PC.
Right, but then you run into the Epidurb case rule. It says you're 100% putting everything on the reputation of the person that the other person is having.
I think it's more than reputation; it's behavior, is what I'm hearing. So there's a consistent behavior that the police recognize as behavior with this individual and how drug transactions occur within this individual, and that your client engaged in that same behavior. And so that transactional behavior was understood to be a drug exchange,
right?
Based on the pattern that had already been created by the drug trafficker.
But still, they suspected it was a drug. I mean, I think that the court needs to keep in mind the distinction between probable cause and reasonable suspicion. You've got a reasonable suspicion here. But you don't have probable cause until they see what's exchanged. So if there are no further questions, I'd ask that the court would reverse. Thank you.
To briefly respond to a few of...
So you'll be arguing the next case, right? Okay, so we will revisit timing.
Okay.
Okay?
Okay, thank you. To briefly respond to a few of Ms. Steer's points. With whether or not there's an urgency for this to be addressed by the Ohio Supreme Court, the only potential snare that I see coming up soon is... and I looked this morning at the cases where the trial court, one of our trial courts, actually did refuse to apply Reagan-Tokes and held it to be unconstitutional. When you look on ODRC's website, they are still listing the indefinite term for those inmates. So I can see that as a potential problem coming down the pipe.
Where a trial court did not sentence the person under Reagan-Tokes and the judgment entry has a definite term, you're saying that ODRC has the Reagan-Tokes sentence on there?
Yes.
Okay.
So that's going to come up sometime. It could be a potential big snare. The 7 districts that found Reagan-Tokes constitutional, we would submit. The 8 districts, I've been saying that wrong this whole time, Del Valle. Oh, I'm going to keep messing it up, I know. It was,
you know what you meant.
It was a fractured, I can't even tell you if it's plurality because there are so many, this judge agrees with this part only in judgment. I'm not even sure if that's the true plurality, but I think it is. Anyway, obviously it's a highly divisive issue with lots of nuances that we still think are not fully explored by any court. The problem with Del Valle is in the beginning when the court, the majority, or the lead, I guess, opinion, goes through, in the beginning of their constitutional analysis, they go through what they see are the policy or reasons behind it, and they say that it's a rehabilitative return to indefinite sentencing, which I think every inmate would probably disagree with that. But the problem is they then go on to cite the Columbus Dispatch, the TimesReporter.com, which is a local Akron paper from what I found, and then True Crime Daily, which is owned by Warner Brothers Entertainment, as their sources for sussing out the policy. I think that's a big problem. Legislative policy needs to be gleaned from official documents, and I don't know how that works with them putting out reports to say what their policy is, but we are left with just trying to figure it out from the statute itself.
Well, I think one thing that is left unaddressed is we keep using the term indeterminate sentencing, right?
Yes.
and we're using this term, and it was specifically at that time, there was a max set, and that's what the defendant was apprised of.
Yes.
And the parole board was able to, as was said, mitigate that, right? But now we're using the indeterminate sentencing for Reagan-Tokes, which operates differently. So we're using the same term for two things that operate differently.
That is true.
And then I think that it's interesting, the argument that the constitutionality was already determined. Well, it was determined when it meant one thing, and now it means something else. It's just an interesting observation.
That is, and I've actually thought it's difficult because life tail crimes are, for one, they're the most heinous. They're their own statutory creature. It is difficult to try to analogize this to that. I think that's maybe the best they've got. And Del Valle did say in different parts of the opinion that this was kind of like parole eligibility, but also kind of like parole revocation. And those are two completely different proceedings. So it's kind of apples to oranges, and I don't envy your task here at trying to figure out constitutional issues. Also quickly, the argument, counsel's argument that DRC doesn't have unfettered discretion, we would respectfully disagree because as Judge Bach seized upon, if you look at just the words of the statute, there's not a whole lot in there requirement-wise. So the inmate, there's not even a requirement they have to be there, they have to be notified, they get to say anything. If you look at just the statute, we submit you need that policy to assess the constitutionality, otherwise the statute doesn't pass muster or even begin to. That's all I had for rebuttal. I can reserve the rest of my arguments for the next case if this panel has no more questions. Okay, thank you.
Thank you so much. All right, thank you, all three of you, for your arguments this morning. We'll take the matter into submission and issue a timely decision. Have a wonderful afternoon. So we now have State of Ohio versus James Edwards. So let's talk about time again. So the last argument, we allotted 20 minutes for each side. And I'm inclined to allot 30 minutes, and if you use less, that's fine. If both,
That's fine with me, Your Honor. That's fine.
okay. All righty.
Please support, opposing counsel.
I was going to ask you,
Sure.
I wanted to just wait until we moved on to the next case. I'm having a hard time understanding why your argument is that we need to take into account the policy.
Right.
If you look at the Del Valle dissent, which is arguing what you're trying to argue, they did not take into account the policy or said that we shouldn't. The state is saying we shouldn't take into account the policy.
Right.
My understanding is this policy wasn't even in effect when your client was sentenced. It was like a year later.
That's right.
So if we're trying to determine facial constitutionality, especially with the due process, don't we just look at the words of the statute?
That would actually be, for my client's position, that would be the most beneficial. And it's only because the Del Valle lead went into that policy, and I figured that it would be potentially giving short shrift. I mean, you can wait for a writ down the road. You can see if the Ohio Supreme Court decides this in the interim, but I think that it's going to behoove everyone to just get in front of the issues now. If you do, and again, our position is if you look at just the words of the statute, then it doesn't pass procedural due process scrutiny.
But at the time, your client, and I believe in this Edwards case, actually raised the constitutionality of Reagan-Tokes at the time of his sentencing, right?
Right.
This policy wasn't in effect at the time.
Right.
So that, I mean, this couldn't even be examined.
Right.
So that's where I'm at. I'm just like, why do we even bother looking at this? Why don't we just look at the statutory language and determine if it's constitutional?
Right, and that is what if you look on, Lexis or Westlaw and look at that policy, plug that in, so many courts have said exactly that. That wasn't in effect at the time, we're not going to go over it. And so we would be fine with excising the policy from consideration and looking at just the words of the statute. And if you do that, then it is even more problematic.
And explain how.
So the statute, I believe it says, one major point is that the subsection C is where they say they're entitled to a hearing. And subsection C is where DRC assesses whether the presumption of release has been rebutted. And the hearing references that section. After that finding is made, there's a subsection D, which is how much longer? How much longer of the max are they going to serve? There is no hearing attached to that whatsoever. So that's a whole second half of how long that we have no process. We have, even in the statute itself, there's no hearing attached to that. The hearing attaches to the subsection C, rebuttable presumption finding.
But what I don't understand is that when you're just evaluating the statutory language for procedural due process, what exactly needs to be in the statute? Because, when I looked at the parole revocation statute, there's not much in that. Yeah. I mean, it doesn't even expressly say that there's any due process safeguards, to my understanding. It does expressly delegate rulemaking authority to the DRC. But that's pretty much it. And so then you've got your, I guess, administrative code that goes through the entire process. Right. So I'm having a hard time understanding, for evaluating a procedural due process challenge, what exactly does the statute have to say?
I think that at least, if you just go back to Matthews versus Eldridge, and we need very simple, we need the notice and the opportunity to be heard. So our due process argument on that front is two-pronged. It is that the notice, if you look at our first notice sub-argument, is that when you say that a violation of all of any rule being held for the year, in the year prior in restrictive housing, that's easy to figure out what that means. But then any rule infraction or any violation of law, that is very broad. So to say that the inmate has notice based upon just the statute of what exactly can cause them to be held, we would argue that the statute is deficient on the notice front.
That's the notice deficiency.
That's the, if we're looking at just the statute language, yes.
Is what could cause him to be held longer needs to be in the statute.
Or at least more narrowly tailored in the statutory language.
Okay.
That's the first. Let me see really quick. The other thing is that the inmate, and with parole and post-release control revocation, correct me if I'm wrong, but I think that the reason that those pass constitutional muster is because there is a hearing. You don't have a right to for eligibility for parole. You don't have a right to release. There's a hope, but you have a right to a hearing. And I think that is why that passes muster. And here,
eligibility actually spells that out a little bit more, right? That actual statute.
Yeah, and I think that's why that passes muster is this. You need at least the hearing. And in Reagan-Tokes, again, part of it they specify there's a hearing, and part of it there's not. So that arguably just as important to the inmate. How much longer am I going to be here? Because some of these maximum terms are quite significant.
Why does the revocation statute pass muster when there's no express procedural due process safeguards in that?
From what I understand, as the case law has sussed out these issues with revocation, and I know that Del Valle, I was confused by one of their findings that there's not, they said something like there's no rights counsel with that, but as the case law has sussed out the constitutional issues, there's a lot of heightened rights that I see have been attached. And that, if you don't want to look at the policy, but that they ended up reflecting in the parole revocation.
Is that the Morrissey case that?
The Morrissey, yeah.
That requires all of that?
Yeah, so when you see what is required for parole revocation, it is almost like a mini trial. Right. So I think that is why the parole revocation and all that, it went through its growing pains like we're doing now, and it passed muster when they did look at the protections that ended up being provided.
But the statute itself doesn't have those.
Right, but I think that that's how it evolved. And so I don't want to call it ripe though, because it has to be, all of this kind of has to be ripe if it's part of the sentence. you have to be able to look at now, or it doesn't pass separation of powers. So I don't get that argument, we can't look at all this now. Whether a direct appeal versus a writ is, I got that question last week, what's the proper vehicle? And that's a closer, from the little bit that I've read of administrative law, that's the closer question. But the problem is that if you want to get in front of this, writs, there's no right to counsel. It's a collateral civil attack. So these inmates are not going to articulate these issues. It's highly, highly unlikely. So if you want to get in front of it, or if the High Supreme Court wants to get in front of it, it just behooves the court to go ahead and just get these tough issues decided on these direct appeals. I think what I'll do, since we, bled into, in the Reed case, we got into some of the other arguments, is try to hit the stuff that we didn't get to.
And I didn't ask you, did you want to reserve time?
Oh, yes, I'm sorry. I'll reserve 5 minutes.
Okay,
Thank you, sorry about that.
no worries.
So, we would submit that for, substantive due process is a difficult way to try to attack this, only because the whole concept is difficult. So going back to Judge Krause, one of your questions earlier, and Reed, even if we can say that rebuttable presumption does create a liberty interest for substantive due process purposes. So if that is indeed a statutory liberty interest that's created, then there are certain rights that attach to that. And I know that there's this whole dichotomy that, yes, but an inmate doesn't have, once someone breaks the law and is convicted, they don't have the same rights as regular citizens. Absolutely true. There's the famous quote from the U.S. Supreme Court case, but there is no iron curtain drawn between the inmate and the rest of society. So some rights does not equal none. And it would remain what rights should they be afforded? Should they be afforded the whole panoply? I've never said that word out loud. It's a weird word. The whole panoply of constitutional rights. And I don't know that I would go that far, but if we do want to analogize to parole and post-release control revocation, that is where maybe the analysis and the analogies can be drawn. That's what Dove Valley did go ahead and say, yes, this is like the parole revocation. But if you look at that policy, which is policy 9, there is advance notice of actual what they're being accused of. That notice is provided to either they can name counsel they want to represent them, or they can ask for public representation to be appointed. That notice is given to counsel. So there's this advance notice of what the allegations are going to be that for parole revocation is that you violated, but for us it would be that you've done something in prison under Reagan-Tokes that should keep you in prison. So there would be actual notice of those facts. And then the inmate would have a chance to, muster their own evidence, gather their own arguments, present. There are numerous, for parole eligibility, that's even less process, but it's still more than this. So, and I actually think...
And you're basing this on the reading of this policy.
Right.
And I was going to ask you, just to clarify what you were just saying. So does this policy, it provides, I guess, 30-day notice
Right.
to the person to let them know that there's going to be this presumption hearing?
Right.
But it doesn't require notice of why or what they're going to use to rebut the presumption?
Correct.
So the person just shows up
Right. In the dark.
without having been able to prepare?
Right. That's part
Okay.
of the argument of the notice problem.
Okay.
And even when it's, parole eligibility, which is policy 3, the offender, the funny part is in that policy, it actually says the purpose of the policy is to afford meaningful consideration in a fair and objective manner. So they even wrote in due process, at least in spirit, right in there. There are these monthly hearings where the person can appear and in advance, before their actual parole eligibility hearing, provide their proof, their documents, videos, whatever they have. They can have other people come in and provide the same to the parole board. And I think another important safeguard is that you have the parole board, the active and current members of the board making these decisions. So, there's a reason we have 3 of you up here right now. It's more brains to review something tends to be a fairer versus one person.
Now, how does that work exactly? I was trying to understand. So we have ODRC, they're the ones who are going to rebut the presumption.
Right.
And then we have a member of ODRC who's going to decide if ODRC rebutted the presumption?
Right.
That's what happens?
Right. That was one of the lines I typed in my outline that was just kind of funny is ODRC decides you violated, and then ODRC presides over a hearing prosecuted by ODRC. It's all ODRC. And
So
then,
there's really not a neutral decision maker?
no, there's not. And part of the problem with all of this is that, and then there's no review afterward. So,
Can you go into that a little bit more?
yeah, so on the tail end of the Reagan-Stokes additional term hearing, so there's this hearing where they decide, was the presumption rebutted? Yes. For one, that fact just has to be, quote, noted in the minutes. So there's no explanation required versus the parole realm when they actually have to issue a written findings. So just noted in the minutes what they decided. Then there's no Part D hearing, so how long? So it goes to the hearing officer is the one who gets to decide up to 365 days what to add on. So that's a unilateral, doesn't have to write it down, commemorated nowhere, reviewed by no one.
So for each presumption rebuttal hearing, they can add on up to a year?
No. So unilaterally, that hearing officer that presides can add up to 365 days. If they want to do more, then it goes to, I forget the title of the person. Hold on, I'm sorry. It goes to the chief hearing officer. It goes to the chief hearing officer if they want to give more than a year. And again, then that person decides. And there's something called an additional term hearing grid to help guide them how much above a year, and I couldn't find that anywhere. But this, again, is done behind closed doors. It's one person who doesn't.
Is it recorded?
No, not that, at least the statute and policy don't say it has to be. There's no commemoration whatsoever, no review. That's just, from what I can tell, from what I've read, a unilateral behind closed doors decision. And then it actually specifies the decision is final and non-appealable. So that is it. Versus the parole processes where it is a parole board, it is a majority, it's numerous people, and then it is subject to review, and there's even a separate policy that talks about reconsideration of parole decisions. So there's just, again, much more process afforded. So for the Del Valle Court to analogize to parole, but then to cut off that analysis and say, but we're not going to consider the policy, I don't see how you can use the policy to fill in the statutory gaps, but then say, but we're not considering the policy. That makes no sense to me.
There's only one hearing, right, that would ever take place, and that's the presumption rebuttal hearing.
Correct.
It's not like they would have I mean, they get their extra time, and then that's that, and then they get out after that.
Correct.
Okay.
I presume unless they don't give them the max and it happens again, then there'll be a separate, based upon new infractions, I guess, if that could be a separate hearing. Say they have two more years on the end, and they decide to only give them one of those years, and then in that 1 year they violate again, they could have, I guess, another hearing. I don't even know if I would think they would have to.
But that wouldn't be a that wouldn't be a
It's a whole different
presumption
creature.
rebuttal hearing.
No.
So
No, it wouldn't be. It's a whole different
Right.
creature.
Yeah.
I haven't thought about that till just now. The other thing that none of the courts that I've seen so far have addressed is equal protection, and this becomes problematic. Number one, defining the class is easy. It's F1 and F2 non-life offenders. Done. Determining the level of scrutiny, there's, common law was a long time ago. The rational basis, intermediate, and strict scrutiny. I know that intermediate is very, very rare. That is not invoked a lot. The problem with conducting either rational basis or strict scrutiny is, again, we need to go to, for rational basis is, does the law at issue, is it rationally related to a legitimate state end? And then strict scrutiny, is it a fundamental right or that is justified by a compelling state interest? The problem is that latter half. We can't suss out, go back to the beginning of my argument, we can't suss out those interests because they're not spelled out. And Del Valle resorted to local newspapers, which I would not advocate. So we need to just guess those purposes. And I think that that's part of the problem.
you're saying there's no legislative history? I thought the newspapers were quoting
I think they might.
legislative history.
I think they quoted maybe one line from a state senator or something. But when I looked at, when I first wrote these briefs forever ago, I tried to look for bill analyses, and there were none published yet. So I confess I didn't go back before argument to look and see, but Del Valle was just released, Del Valle 2 was just released a couple of months ago. And they are citing, quoting Senator Kevin Bacon,
describing the Reagan-Tokes law. The Times reporter doesn't say what they're doing. And then I want to say True Crime Daily, they're quoting an Ohio State rep. So they're quoting what individual two people have said. And I don't think that that's enough to suss out. We need to conduct a proper equal protection analysis. We need, what are your purposes? And what I did is try to suss out from context, what are they trying to achieve here? So they're trying to achieve the inmates to comply with the code of conduct in prison. They've got their rules, don't break our rules, don't get in fights, don't break the law while you're in here. But we would argue that, at least for the strict scrutiny, even for rational basis, that there is already existent means to address those. There's the Rules Infraction Board, which has its own hearing and process. There are, if they do commit a crime in prison, they can be prosecuted for that. So it would stand to reason, if there's already means to handle these objectives, that it's not the, they don't need to create higher means. It doesn't survive that scrutiny.
Aren't the underpinnings of Reagan-Tokes that the idea is that the individual in that case had all of these infractions and had thus not exhibited rehabilitation,
Right.
and thus when they served their sentence and was released, despite the fact of their behavior while incarcerated, then there was a tragic reoffense.
Right.
So it seems to me that the state might argue that the state interest is to protect society from people that are not rehabilitated.
And that would make sense, but the problem is that this is, and the Reagan-Tokes case itself is terrible. The issue is that then the desire to try to control someone after their period of release affects everyone else who was ever sentenced in Ohio from here on out. And you have to balance that there is a liberty interest, especially when someone is released. Prison, for one, is a very different environment. I have not been, but I have heard that.
Well, why don't you just address that state interest? Let's say that the state interest is to protect society from folks that are not rehabilitated, and so that I'm going to call it the default sentence.
Okay.
So I know everyone's calling it the minimum sentence. I'm going to call it the default sentence. That a default sentence then doesn't suffice.
And it would, I don't dispute that it could potentially achieve that end of keeping someone in longer who has a problem in prison. But you have to balance that against, you're depriving everyone of their liberty. And at least,
I think the question that I would have is whether rehabilitation, how does that play into the sentencing? Because in effect, what we're doing is creating rehabilitation as a factor in determining what the actual sentence will be as carried out.
I know that is a stated, at least Del Valle went back to, the whole Reagan-Tokes brings back the rehabilitative aspect of sentencing. And I found that confounding, because imposing more punishment on top of previous punishment, I don't think is going to curb someone's behavior once they get out. In fact, I think it'll, if anything, make them more resentful. The prison environment, where if people do get in fights, there is still some gang activity. It is just totally different from free society. So,
But they're not getting more punishment. I mean, there's a range. The person knows that they have a range.
right.
And so I guess that the argument is that this is going to incentivize them to be good in prison so that they can get out early or get out with the minimum.
And there's more punishment versus the definite sentence that this scheme replaced. So it was definite, for an F1, you get through it 11 years, period. So now there is more potential above that. We would still submit that, especially if the infraction happened, for the rule infraction board, for the rule infraction finding and for the violation of law. I think those are broader. The restrictive housing was within a restrictive confinement or whatever was within the year prior. So let's say it even is a year prior. I don't think that
imposing an additional term later is really going to incentivize that inmate who a year or more before committed this infraction, and they're going to think ahead to, oh, I shouldn't have done that a year ago. It's, if there is one of these, gang-related or anything, negative interaction, someone punched me and I fought back, that is just a different norm than out in free society. So I don't think that I think it is sort of a farce that's saying that this really is going to be rehabilitative. I don't believe it is going to be, and I understand.
We don't have to agree with the state interest, but
Right.
we just have to find that there is one.
Yeah,
That
that's
sounds
true.
like what they're trying to do, is incentivize people to rehabilitate.
And then, but the latter part of that analysis is going to be, for one, is it a compelling state interest under strict scrutiny? Okay, I can agree with that. But is it narrowly tailored to achieve that interest? And that's where we would argue that it doesn't meet the latter part of that, or the least restrictive alternative. And again, the existent means can still achieve that, even if the existent means, rule hearings, solitary confinement, if those are not meeting the end in the way that is desired, I understand the desire to want to control someone past the prison term, but you can't just do that. You can't just impose, let's just keep adding on time and infringing upon someone's liberty. And that is what they're doing. It's kind of controlling someone beyond the grave. There is this finite term that it goes back to, the term of incarceration goes back to what you did for the crime you were convicted of. This goes beyond that. And you really have to balance that liberty interest. Is the interest in the rest of society to be free? Is it okay to infringe that? Is that the least restrictive alternative? And we would say that it is not, just because there are existing means.
Can you go back to, you touched on this very briefly, why it would be strict scrutiny?
So we advocate for strict scrutiny only because that is attendant to fundamental rights. And if we go back to the earlier argument that it is the Sandin versus Connor out of the U.S. Supreme Court that says that the Fourth Amendment liberty right is the most fundamental of all, that rises of its own accord. So that is what is kind of directly implicated by this holding someone longer, is the fundamental liberty interest. And then the rights that are usually attendant to that. And when someone is incarcerated, yes, they give up certain rights. But again, narrow or few rights is not none. So, and this kind of, does blur the lines between our due process and equal protection arguments. But we would argue that strict scrutiny applies because it does involve that fundamental liberty interest that just arises of its own accord, like under the Sandin court said. And so when there's that deprivation of liberty, there are certain rights that really akin to the parole revocation hearing, that if Reagan-Tokes afforded someone all those that are in that policy, I think our argument today would be exceedingly difficult. I don't know what I would get up here and say. If they had all that notice and all the process afforded and all the rights, and it's not just this, what I call in the brief, incestuous tongue-in-cheek, but ODRC prosecuting, presiding, deciding, and adding on the time.
I'll add to that, no right to an attorney.
Right. So that's, it's important, and
But if we don't consider the policy, and we
Right.
just look at the statutory language, and it kind of goes back to my question of, that's what we have, that's our first question. Do we consider the policy or do we not consider the policy?
right.
But if we're just looking at the statutory language, the parole revocation, going back to what I said, does not spell anything out. It simply delegates rulemaking authority.
Right, but that wasn't upheld until the rest of it was litigated. You know what I mean? It did get challenged, and it eventually was upheld, I think, because of the processes that were put into place. So is it a timing issue? Is that all before this court? Not if it doesn't want it to be. So is that what that comes down to? But if you want to get in front of it, you can. Perhaps the High Supreme Court will. I certainly hope so, because I think without the policy stuff, I don't see how the statute by itself, when it entails this deprivation of liberty, I don't see how it holds water, passes muster for at least procedural due process. That's the one I keep going back to, but
You have 1 minute left.
What's that?
You have 1 minute of your 25.
Okay, I was going to say, I don't think, between Reed and this argument, I don't think I'll get into anything additional unless the panel has any further questions. I'll reserve the remainder. Okay,
Thank you.
Thank you.
anywhere close to taking up 30
I
minutes.
don't know. Your predecessor said the same.
Yes, well, what I would like to do is, and I did this last week, is
Well,
to
you have the
search-
30 minutes, you can use whatever you want.
Thank you. And because I think it's easy to get hung up on these policies, and I don't want to do that. I think that the best guidance that this court has, and I think we're fortunate in this regard, is that we have Woods v. Telp. And I don't want the court to disregard the guidance that we get from that when they analyze the PRC statute and that. And I think that why that's important is this kind of goes to the ripeness issue. And what I like about the Diwali 2 case is that it does simplify what's involved here is the imposition of sentence. That's where we're at right now. That's what the statutory language that we're looking at. Everything else is how that sentence is carried out, how you said before, Judge Zayas. And if we step back away from this issue of the sentence range, look at all of the other policies, if you will, or all of the decisions that DRC is charged with by the executive branch to decide how sentences are carried out. It begins from day one. Where's the person going to be serving their prison term? Which institution, what level of security are they going to be at? All of these things that occur with regard to how that sentence is carried out, there's another mechanism that exists within the judicial system for that person to challenge those. So for us to now analyze and ask all these courts all over the state to analyze, and quite honestly,
But all of those things don't go to the actual sentence.
They
and
do,
what is
how the
time,
sentence is carried out.
What the time is. That's more of the how the time will be, not what the time
And
is.
it's
And the
the
issue
same
at stake
thing
here is
because
the
we know
what.
the sentence is within the range. The court imposed the sentence.
But
and-
here's
and
what's
that's the
interesting
range.
is the court is giving a range, okay? And that range begins, and I'm going to call it default. That's my engineering brain, okay? And I'm not going to call it minimum. I'm going to call it the default sentence. And let's say the default sentence is 5 years. We know that that default sentence is absolutely tied to the crime that there was a conviction of, okay?
Okay.
Then we're calling it a maximum. I'm going to call it a parameter. I'm going to say the trial court set a default and a parameter. What we know for sure is that that default is tied to the conviction. Anything after that default is not tied to the conviction. Anything after that default is not in the hands of the judge. So even the judge set a max or a parameter, the actual sentence that will be served is controlled by ODRC. So I'd like for you to address it in that perspective as to why there's not a separation of powers issue and why there's not a due process issue.
Well, because again, there is that's been imposed by the trial court, and this goes again to many other things that
But the
DRC.
trial court imposed a sentence where that default is absolutely tied to the conviction. Anything that the individual serves after that default is not tied to the conviction, is not tied to the behavior of the conviction. It's only tied to behavior that takes place in the prison system. And okay, we're not going to look at the policy as to what is the procedure in determining what infractions qualify and how it's going to happen during that hearing and the right of attorney. We're not going to look at any of that. But we do know that any behavior that takes place in the prison system is going to determine what is going to go beyond the default. And what the judge has rendered is a parameter that the ODRC cannot go beyond.
Right, and that
So I
is-
want you from that perspective.
Right, and that's
from
no
that
different
perspective
than the
address
indefinite
separation of
sentence.
powers and due process.
And that's no different than indefinite sentences that we had for years. Before that's dating back to,
There, the trial
Peter's
court
case that-
was giving a maximum. That maximum was tied to the behavior and the conviction. And what the parole board was able to do was chisel away at that maximum and give it less. So they were not taking away liberty interest or individual interest. Maybe they were taking away interest to society and but they weren't taking away interest to the individual.
Well, and again, I think that's when we started this morning and Judge Krause asked about how the presumption, does that make any difference? And I think that's what the essence of your question. Now, engineering terms are not are way beyond me, so.
Well, I just think of
Minimum,
default.
maximum is
This is the default because it's the only part, and it's also the only part that is tied to the conviction and the behavior that led that individual to getting that sentence.
I don't agree with that because it's, again, we look at the words of the statute, and the statutes, what they did was it's still tied to the conviction because that's what establishes the minimum. And everyone knows when that minimum is what's used. Now you have a statutory formula. You don't just have these outlandish ranges that we had under the old indefinite sentencing. And now you know you have that presumption. And again, because this is supposed to, and I guess the new key phrase for this is the
Which I also find
incentive
interesting
base.
that we're saying that the judge is setting the maximum when in actuality it's a formula set by the legislature that's setting the maximum.
Correct.
But I'm going to put that aside for now.
Okay.
Okay,
So-
because that opens up a whole other thing.
Right. And so we do, again, we don't need to look beyond the statutory language, all that's factored in. But based on this incentive-based sentencing, if you will, now it is, the defendant does have more knowledge as to, and I believe Judge Shanahan in one of the cases that's before the court on these, paraphrasing it, actually stated it the best that I've seen of anyone, said, the power's on you. Here's your sentence, and where you fall in that range, you can get out at this amount of time, but it's all on you. And I believe on that, too, talked about programming. So again, it does go with what you're, chiseling away at the sentence. There are positive aspects.
It's not really all
too.
on them because it isn't like
because
here's your beginning, here's your possible end, and like, hey, if you do this while you're in prison and you get involved in these programs, we're going to take 6 months off. If you help out in this way while you're in prison, it takes this amount. Those are things that are in control of the detainee at that point. This is, how that is going to be served, the actuality of the sentence. This is what I find interesting because the actuality of the sentence is nobody knows.
And again,
and frankly, that person could be in one prison and the actuality is different, but maybe the policies of another prison creates a different actuality. So to say that it's in their control.
And the state's position is that for this court to analyze the constitutionality of this entire scheme based on this vacuum of, and quite honestly, and that was something I didn't catch, was that these policies weren't in effect at the time that Mr. Ed, because this has been a while now. But
that was the same thing in the Duvall case too, that they mentioned in the Duvall case. The policies weren't in effect. So
Right.
that's when I went to look to see,
Okay.
and I saw they were not.
Right, and that's a very good point. And the fact that we don't know if these policies are going to apply to Mr. Edwards. We
Right,
don't
but I
know
really want to come back to the statutory language.
Right, and
So looking at
that's
the.
why I think Woods v. Telb is the points this court in the right direction.
So
for all of
looking at the
constitutional
statutory
claims.
language where you have a sentence where the part that is determined in the courtroom is tied to a conviction, and the part that's actually going to be added on with a parameter giving the end is determined outside of the courtroom and with behavior that has no connection to the conviction. How is that not a separation of powers issue?
Well, again, post-release control. When you look at post-release control that they analyzed in Woods v. Telb, you have mandatory aspects of post-release control and you have discretionary aspects of post-release control. It's no different. And the analysis that the court engaged in Woods v. Telb, I believe, points this court in the right direction. Even though the court does, or the state does not agree with regard to the equal protection argument that this would involve a fundamental right, because it's a potential, we don't know that a fundamental right is involved here. But even if you do engage in a strict scrutiny analysis, the state believes that this would pass muster. The whole purposes and goals of sentencing have not at all been impacted by Reagan-Tokes. So for this court to go beyond that, you would be saying that, the entire sentencing scheme for felony 1s and 2s wouldn't survive equal protection. But certainly rational basis would be what is applicable.
But you were trying to say that with regard to a separation of powers argument, in your opinion or in your research, the presumption doesn't matter. I mean, this is basically the same as any other indeterminate sentence.
Yes. And I believe that you look at the old, and none of this is briefed or anything, but I just remember when we went from indefinite sentencing to truth in sentencing, which is what it was called in Senate Bill 2, there was a lot, I guess the randomness or the discretionary. I remember reading something that, some defendants felt that, well, I've got Adams, the name Adams, well, of course I'm getting flipped the first time because I've got a criminal name. That just the randomness of that was one of the complaints under the indefinite. Now we have these, more specific and all the, the policies and that have gone into effect. So I think that if the indefinite sentencing scheme that we had for years was okay, then certainly the protections that are afforded to the people being newly sentenced under our new indefinite have to.
But why put a presumption then? Like, why wouldn't we just go back to the indefinite sentencing?
And I think, again, the Diwali case speaks a little bit to that incentive-based sentencing, if you will, that they know that
if they're good, they get out in that minimum time.
Apparently, right.
Could you please address, is there a liberty interest in that presumption?
I don't believe so, because you're being sentenced for, again, a crime, and you're given that range. I don't think that,
But
there's
the statute specifically says shall be released unless the presumption is overcome.
Right. But, and again, that's why doing this right now, when we have...
Well, the Supreme Court's already said it's right, so that question's off the table.
Right. Well, again, there's nothing that, and again, it's just so if a court were, we go back to the definite sentencing scheme, and the person's given, they had the right to judicial relief, there were those other, that we're not looking, this isn't all, we're not forging entirely new ground here. There've always been these little elements that put that, and this is just another way of putting the defendant on notice that, okay, yeah, you've done these horrendous things, you're going to prison for a long time, but, use that time, do what you can to affect your sentence. And I don't think that that's forging new ground. I don't think that, the liberty, again, the range is the range. The judge set the minimum, then the legislative formula that's provided kicks in, and then the maximum is set. Nothing that the defendant does beyond that, the maximum can never change.
But he does have an expectation that he's going to get let out.
There's an expectation, but I don't think, again, the fact that there's the potential, and again, that's what we're working with here is the potential.
It's more than a potential. It's presumption.
No, the potential of an additional range, and that's why it's hard to look at and analyze this when these events haven't occurred. And quite honestly, we don't even know if DRC, we have the policies are put out, but those could again change before they even get implemented. They could decide, we don't even want to mess with this rebutting presumption business. They have the authority to do that.
So this would be what you're saying. When we analyze the statute, we look at the language only. We don't look at the policy. which wasn't even in place at the time these defendants were sentenced. And then any challenge to this policy would have to be made in a habeas later, after somebody has a presumption hearing.
Correct. And that's how all of these other, everything that, and if you look at how the sentence is carried out, that occurs in a habeas fashion.
And that's what was going on in the parole revocation challenges, right? Those were
Correct.
habeases. Yeah.
Right. All right, unless there's any further questions, I will submit. Thank you.
Thank you.
Just a few follow-up points. I think really the state's invocation of Woods v. Telb and the analogy to post-release control is problematic. There is one major similarity, and that is both the imposition of post-release control and the Reagan-Tokes maximum term are, at least on its face, imposed at sentencing as part of the original sentence. That's why it's ripe for review now. That's where the similarities stop. Post-release control, the person is out. They are free. Their liberty is not being deprived. So that is way different than saying,
Slightly being deprived. I mean,
they have conditions.
Yeah.
There's
They're
some
not
things
being,
but
they're
out.
not in the prison.
And I would wager that's the most important thing to any inmate. So it's really not a deprivation of liberty, at least not to the extent that keeping someone in prison is. Also, unlike Reagan-Tokes, as Josiah, as you seized upon, post-release control still flows out of, still goes back to the original sentence, the original actus reus conduct that underscored the conviction. Reagan-Tokes is, by contrast, solely concerned with behavior in prison. So that's another reason that analogy kind of falls apart.
So the length of PRC isn't determined based on the activities in the prison?
I think, and
There's a maximum, but...
I think that the length of PRC, isn't that attendant to, this is a gap in my knowledge, but I thought that was attendant to as a matter of law, like for certain violent offenses, it's gonna be 5 years period. And then there's discretionary PRC.
Some of them, yeah.
Kind of like Adam Walsh, I don't know, I'm not positive. Another point is that we can't, I've seen this argument a lot that but we used to have indefinite sentencing. You know, so that should make it okay today. We also used to not make sex offenders register before Megan's Law. Do we want to go back to that? So that's not really, I would not like to see that written into an opinion. That is not really a justification for upholding it now. Saying that the power is on the inmate is sort of I mean, it's nice in theory, but it's not. So what if an inmate has a case manager who hates them? It happens. They don't get along. If that case manager decides, or I think it's corrections officer, whatever they call them, decides I want to get this guy, or girl, I'm going to throw you into the hole, and boom, you've been in restrictive housing. If it's close enough to their out date, that personal vendetta can keep that inmate in.
But aren't there procedures, there's administrative procedures on challenging that, isn't there? Are there no like if you just can get put in restrictive housing and there's no challenge at all?
Yes, I don't know. I'm not sure if that's part of, I know for rule violations, there's that rule infractions board, but I don't know enough about the inner workings of ODRC.
Right.
The practical effect on the back end of this is if an individual has a personal vendetta against someone they're in charge of or not even in charge of, they just don't like someone, because of how closeted this whole procedure is, because of ODRC's role in every aspect of keeping someone in, that is just ripe for the power is on ODRC. It's not really on the inmate, and if we're being practical about it. And then the last point I would submit is that, at least for the equal protection analysis, that it's difficult to dispute that the presumption does create a liberty interest. That is what there is an expectation akin to when someone is out on parole or post-release control. There's this expectation you're going to stay out, and that is why there's increased procedures to take that liberty back away. So we would argue that liberty interest created by the statutory language is an enforceable interest that does raise the level of scrutiny for this interest. If there are no further questions, we would just ask the court to declare the Reagan-Tokes law and the relevant portions of that Senate bill unconstitutional. Thank you.
Thank you. So that concludes our arguments for this morning. We will take the case, the matter under submission, issue a timely decision, and have a wonderful week. Thank you.
Court of Appeals